So, if we go back to the fall of 1847, the United States military did something that was, almost entirely unprecedented in modern warfare at the time.
Oh, absolutely. It was a massive escalation.
Right. You've got American troops, they're commanded by General Winfield Scott, and they literally march directly into the heart of a neighboring sovereign nation and just capture its capital.
Oh, right.
Like, the American flag was physically flying over the halls of Montezuma in Mexico City.
Yeah, the Mexican government was completely fractured at that point. Retreating, totally incapable of mounting any sort of coordinated defense.
Exactly. So the U.S. had won. They had effectively conquered the entire country. And back in Washington, D.C., there's this massive, really vocal political movement demanding that the U.S. just, swallow Mexico whole, annex the entire thing.
Which, to be fair, is what empires usually do, right?
Yeah.
When they have their boot on the neck of a defeated rival, they take everything.
Right, but they didn't do it. They just packed up, took the relatively empty northern half of the country, and gave the really densely populated southern half back. So why? Why build an empire and then suddenly just hit the brakes?
Well, that decision to stop halfway, it's really the key that unlocks this entire era of American history. Because the answer isn't strategic, and it certainly isn't economic.
Because if you're a traditional empire, you want all the resources, right? You want dominance.
Exactly. You take everything on the table. The only way to understand that specific moment in 1847 is to look at a deeply ingrained ideology that basically functioned as a blueprint. A blueprint that boils down to a single, pretty devastating doctrine, which is take the land, not the people.
Take the land, not the people. Okay, let's unpack this. Welcome to the deep dive. And if you, our listener, have been following our series, we usually tackle like a single event or maybe a biography, but today we're doing something different.
We're setting up a historical courtroom.
Yeah, a massive historical courtroom just for you. Because we've gathered this really fascinating stack of sources for today's mission. We've got legal treaties, state penal codes, and historical scholarship from brilliant minds, Laura E. Gómez, Reginald Horsman, Amy S. Greenberg. We even have modern Supreme Court rulings that are making headlines right now, literally in 2026.
The docket is definitely vast, but the driving charge we're examining is incredibly specific. We are asking you to weigh the evidence and determine what actually drove 19th century American territorial expansion.
Specifically the Mexican-American War and that whole era of, rogue military invasions, the filibusters that followed it.
Right. Are these events best understood through the lens of racial ideology, or were they driven by the messy mechanics of political contingency, the domestic battle over slavery, and just raw commercial greed?
So we're putting race on one side of the scale and commerce and politics on the other. And I want to be really clear about the stakes here, because this isn't just dusty history about guys in wool coats debating in the 1840s.
Not at all.
That blueprint, taking the land, but legally isolating the people living on it, it created the architecture for how the United States handles borders, citizenship, and territorial rights to this very day. The echoes of the Mexican-American War are literally ringing in the halls of the Supreme Court right now.
They really are. But to understand the present, we have to go back to the exact moment the military warfare ended, because that is when a totally new kind of legal warfare began.
Right, the broken promises of 1848. So let's start there.
Yeah, so the transition from military conquest to legal administration, it happens with the Treaty of Guadalupe Hidalgo. That was signed on February 2, 1848. And just the sheer geographical scale of this document is staggering.
It's massive. With a single signature, the U.S. annexed roughly 55% of Mexico's sovereign territory.
Which is an unthinkable amount of land. We are talking about the entirety of present-day California, Nevada, Utah, most of Arizona and New Mexico, and significant chunks of Colorado and Wyoming.
Over half of a neighboring nation transferred in a single diplomatic maneuver.
Right. But the immediate logistical problem the United States faced was that this newly acquired half a continent, it wasn't empty.
No, not at all.
There were an estimated 100,000 Mexican citizens living in that vast territory, with heavy concentrations in places like New Mexico and California. So the treaty had to address their legal status. This is the origin of Articles 8 and IX of the Treaty of Guadalupe Hidalgo.
And these articles, they contained explicit formal promises to the Mexican people who suddenly woke up to find, the border had just crossed them.
Yes. And if you read the text of the treaty in a vacuum, It actually looks incredibly generous. The U.S. government basically promises two main things.
Right. First, if you choose to stay in this new American territory, your property rights will be inviolably respected, meaning the land you owned under Mexican law is still your land under American law.
Exactly. And second, it promised them a path to full U.S. citizenship, so it looks like a document of inclusion, almost a welcome mat.
But the reality was a little different.
It was a lot different. It functioned as a diplomatic necessity to get the Mexican government to agree to the peace. But the domestic political will within the U.S. to actually honor those articles was completely non-existent.
Wow.
The Concrete Society had zero intention of incorporating a landed, wealthy Mexican elite into its economic or political structure. And the clearest instrument used to break that treaty promise, the ultimate weapon of dispossession, was the California Land Act of 1851.
The California Land Act, it's breathtaking when you look at the actual mechanics of how this thing worked.
Oh, it's brilliant and brutal. Congress officially titled it an act to ascertain and settle the private land claims in the state of California. And the genius of this legislation was in how it manipulated the burden of proof.
Okay, break that down for us, because in standard common law, right, if you hold a title to land, the government presumes your ownership is valid.
Yes, the burden of proof normally rests on the government or a challenger to prove your title is somehow defective.
But Congress just flipped that entirely.
They completely flipped it. They required every single Spanish and Mexican grantee to actively prove their title before a newly established Federal Board of Land Commissioners. The presumption was suddenly that your land was public domain, meaning it belonged to the U.S. government, until you could conclusively prove otherwise.
To a panel of American judges, in English, under an American legal framework.
Exactly.
I mean, imagine this happening to you today. You've lived in your house for generations, your family built it, you've farmed the land, your grandparents are buried out back. A new government takes over and tells you they are honoring your property.
A generous promise.
But then, a few years later, they pass a law saying, actually, we presume this is our house now. You have to spend the next 2 decades in our federal courts proving it's yours. And while you do that, you have to sell off pieces of your living room just to pay the lawyers to defend your right to own the house. It's a rigged game from day one.
It really was designed to produce a specific outcome. And to truly understand how this structural rigging played out, we have to trace the human element. The abstract legal theory translates to absolute ruin when applied to actual families.
Right, like the Californios, the established land-owning elites of Mexican California.
Families like the Picos, the Bandinis, the Baleos, and let's look closely at the Peralta family. Domingo Peralta and his family were the holders of the massive Rancho San Antonio.
And this wasn't just a small farm, right?
Oh, no. This grant encompassed almost the entire modern East Bay area of San Francisco, modern-day Oakland, Berkeley, Alameda, San Leandro. They had held this land securely since a Spanish land grant issued in 1820. They ran massive cattle operations. They were the undisputed economic powerhouses of the region.
And then comes the 1848 treaty, followed immediately by the 1849 gold rush, and then this Land Act of 1851. The gold rush is essentially the gasoline poured on this legal fire.
Absolutely.
Yeah.
Because suddenly you have hundreds of thousands of Anglo settlers pouring into California looking for wealth, and they need land. And they look at these massive Mexican ranchos and just decide they want them.
So under the 1851 Act, Domingo Peralta's 1820 grant is suddenly considered suspect.
Right. He's forced to file a claim with the Board of Land Commissioners, and the first barrier is just language and legal translation. The Spanish and Mexican land grant systems didn't use the precise, rigid GPS coordinate grid system favored by American surveyors.
They used diseños, right, which were like hand-drawn topographical maps.
Yeah, exactly.
Yeah.
A boundary might be described as running, from the skull of the cow on the hillside down to the large oak tree by the creek.
Which makes perfect sense if you live in the community and everyone agrees where the oak tree is. But if you put that in front of a federal judge from Massachusetts, it looks like legal nonsense.
So to bridge that gap, Peralta had to hire American lawyers in San Francisco. And these lawyers knew they held all the leverage, so they often demanded payment in land. They'd take a third, sometimes half of the rancho, just as a retainer fee, to take the case before the commission.
Half your land just to hire the lawyer to keep your land.
Yes. And while this case is sitting in the administrative backlog, those gold rush settlers you mentioned, they're utilizing American preemption laws. They pour onto Peralta's property and literally set up camps, build houses, start farming his land.
Because they know the title is technically in dispute under federal law, so they just declare the land public domain and claim squatters' rights.
Right, so Domingo Peralta is fighting war on two fronts. He's fighting the federal government in court, and he's fighting armed squatters on his own property. And this legal process was agonizingly slow. The average adjudication for a California land grant took 17 years.
17 years of legal purgatory.
Think about that timeline. Let's say the Board of Land Commissioners actually looks at the diseños, hears the testimony, and confirms Peralta's title in 1854. He wins the first round.
Okay, good for him.
But wait, the law allowed the U.S. government to automatically appeal any confirmation to the federal district court. So the government appeals. Peralta has to pay his lawyers again to fight the appeal. That takes another 5 years.
Oh, man.
Let's say he wins in district court. The government, or the organized squatter associations, they appeal it to the United States Supreme Court in Washington, D.C. So now Peralta has to hire specialized appellate lawyers back east.
All the while, the new state of California is levying American property taxes on his entire estate. But he can't actually generate income from large chunks of it because it's physically occupied by squatters.
And then the 1860s hit, bringing massive, multi-year droughts to California. The Peralta cattle herds, which were their primary source of wealth and liquidity, are decimated.
So you have a family paying crushing property taxes on land they can't use, paying exorbitant legal fees for a case stretching across decades, and losing their underlying economic engine to environmental disaster.
It's death by 1,000 legal cuts. The process itself is the punishment. By the time the titles were definitively confirmed by the Supreme Court for many of these families in the 1870s, it was just a hollow victory.
The legal costs and the compounded debt had completely ruined them.
Exactly. To pay off the loans they took out just to survive the litigation, they had to sell the very land the Supreme Court had just told them they owned. By the end of the 1870s, the great California estates had almost entirely passed into Anglo hands. The United States kept the land, but through the mechanism of the 1851 Land Act, it actively shed the people who owned it.
I do want to pause here and maybe challenge this narrative slightly because a good courtroom needs a defense. I was reading through Amy S. Greenberg's notes in our source stack, and historians point out that the transition from a Spanish civil law system to an English common law system is inherently chaotic.
Oh, there is friction, undeniably.
Right, so was this dispossession really a calculated, deliberate strategy of racial removal? Or was it just the tragic bureaucratic friction of merging two incompatible legal systems? Because, some Anglo settlers who bought land in good faith also got tangled in these title disputes.
It's a fair question, and it is absolutely true that the legal transition was messy. Some titles were genuinely fraudulent or ambiguous, but the structure of the law reveals the intent.
How so?
If the primary goal of the U.S. Congress was simply to clarify titles and establish order, they could have honored the standard legal presumption. They could have declared all existing titles valid and put the burden on the federal government to investigate and challenge specific cases of suspected fraud.
But they didn't do that.
No. By reversing the burden of proof and placing the presumption against the property holder, Congress transformed an administrative challenge into an engine of systemic dispossession. They built a machine designed to clear the board.
So the empire successfully secures the land and clears out the wealthy Mexican landowners through this war of legal attrition. But they're still left with a massive demographic problem. What do you do with the roughly 100,000 Mexican people who are still physically standing in this new American territory?
Right, because taking their rancho doesn't make them disappear.
Exactly. To solve that puzzle, the U.S. legal system had to engage in this really profound act of social engineering. They essentially had to invent a new racial category. Here's where it gets really interesting.
This brings us to the core argument of sociologist and legal scholar Laura E. Gómez, particularly her highly influential book, Manifest Destinies. Gómez challenges our basic modern assumptions about how race operates.
She argues that the Mexican-American race was not a natural biological fact that the United States simply bumped into when they crossed the Rio Grande.
Precisely. It was a demographic reality that was actively manufactured by the war and its legal aftermath.
The idea that a race is manufactured by a legal system is, it's a tough concept to wrap your head around initially. Let's break down the paradox she identifies, which revolves around something she calls legal whiteness.
To understand legal whiteness in 1848, we have to look back to the very foundations of American citizenship, the Naturalization Act of 1790. This was the first law defining who could become a U.S. citizen, and it stated unequivocally that naturalization was restricted to free white persons.
Free white persons. And that racial restriction was still the active law of the land when the Treaty of Guadalupe Hidalgo was signed.
And here is the collision. The 1848 treaty promised citizenship to the Mexicans who chose to remain in the acquired territory.
Right.
Therefore, by extending the promise of citizenship through the treaty, the United States legal system was forced into a bizarre corner. To make the treaty constitutional under the 1790 law, the federal government had to formally, legally classify Mexicans as white.
Wow.
If they were not legally categorized as white, they could not be citizens. So on paper, in federal statutes, a Mexican laborer living in Los Angeles in 1850 was legally considered a white person.
But the reality on the ground, I mean, the lived experience of that laborer in Los Angeles was completely disconnected from that federal legal fiction.
Completely disconnected. Despite possessing this formal statutory whiteness, the daily reality for Mexican Americans was one of profound systemic social subordination. They were pushed into segmented lower-wage labor markets. They were excluded from local juries and political power. In social interactions, they were treated as a distinctly non-white inferior group.
Gómez points out that they were trapped in an agonizing middle space.
Yes, they were legally white enough to satisfy the treaty requirements and federal naturalization laws, but they were socially non-white enough to be exploited, disenfranchised, and pushed to the margins of the new society.
And this wasn't just, unspoken prejudice or nasty looks on the street. The prosecution in our historical courtroom, the side arguing that racial ideology was the driving force, has a literal smoking gun here. This social subordination was explicitly codified into state law. We have to talk about the 1855 California Greaser Act.
The fact that this law existed is just a devastating piece of evidence regarding the central role of race in organizing this new territory.
The official title on the books was the Anti-Vagrancy Act. Vagrancy laws were common tools used to control labor and movement, basically criminalizing unemployment or loitering. But this specific law became known as the Greaser Act because of the actual literal text written into the state penal code.
It's hard to believe it was ever printed.
Section 2 of this statute specifically targeted, and I'm quoting the law here, all persons who are commonly known as greasers or the issue of Spanish and Indian blood, and who go armed and are not peaceable and quiet persons.
The state legislature wrote a vile racial slur directly into a penal statute.
They used a slur as a legal definition to criminalize the ordinary existence and movement of a specific population. The law gave local sheriffs the authority to disarm, arrest, and put to forced labor any Mexican American they deemed not peaceable.
Now, a year later, the legislature realized they had perhaps been a bit too explicit and quietly struck the actual slur from the text.
But the enforcement pattern had been established. The police power of the state was being utilized to legally harass and control the very people the federal government had deemed white citizens just a few years prior.
The Greaser Act perfectly illustrates Gómez's thesis. Race functions as a technology of power. The United States needed to maintain tight control over the immense resources of California, especially during the chaos of the gold rush.
Right.
To consolidate that control, they needed to subordinate the pre-existing population. They utilized the legal system to manufacture this new racial category of the subordinate Mexican as a structural tool to ensure Anglo dominance in the region.
Now, to maintain the balance of our deep dive, we need to contrast Gómez's perspective with the broader historiography. The defense might argue that the U.S. didn't just, invent prejudice out of thin air in 1848.
It's an important nuance. Critics of the pure manufacturer thesis point out that pre-1848, Mexico was not some egalitarian utopia. The Spanish colonial system had spent centuries developing its own incredibly complex racial hierarchies known as the casta system.
Right, the castas.
This system strictly stratified society based on precise degrees of Spanish, indigenous, and African ancestry. So racial hierarchies and prejudices were already deeply embedded in the territory.
So the American system just adapted what was already there.
Not exactly adapted.
Well,
What Gómez argues is that the U.S. system took the highly complex, multi-layered casta hierarchy and violently flattened it. They weaponized it into a strict non-Anglo binary designed specifically to serve American imperial needs. The U.S. didn't invent racism, but they activated a new, specific kind of racial identity that legally and socially trapped the Mexican population.
this intense racial animus, this structural need to subordinate the Mexican population, leads to one of the most fascinating paradoxes in American history.
It really does.
If the American expansionists felt this strongly about racial hierarchy, and if their ideology was this potent, Why did General Winfield Scott and the politicians back in Washington stop in 1847? They had the military power, they were sitting in the capital. Why not conquer the entire country of Mexico?
To understand why the empire hit the brakes, we have to look at the work of historian Reginald Horsman, specifically his book Race and Manifest Destiny. Horsman explores the deep ideological roots of this era, contrasting perfectly with Gómez.
Because where Gómez looks at the legal application of race on the ground, Horsman looks at the ideological theories debated in the halls of Congress.
Exactly. Horsman argues that the American concept of expansion underwent a massive, dark mutation in the early 19th century. He traces the evolution of American thought. In the early days of the Republic, expansion was often justified by a concept of Republican universalism.
Which was this idealistic, if, naive belief that the American system of liberty and democracy was a universal good and that theoretically anyone who adopted its principles could be embraced by the Republic.
The idea was our political institutions are superior. But by the 1840s, Horsman shows how that idealism had curdled into a virulent, biologically based ideology of racial Anglo-Saxonism.
It was no longer about superior institutions, it was about superior blood.
Right, it became a widespread, mainstream political belief that a superior Anglo-Saxon race was biologically destined by Providence to dominate the North American continent. Consequently, any people standing in the path of that destiny were viewed not just as political rivals, but as biologically inferior obstacles.
So Manifest Destiny wasn't just a catchy political slogan, it was a deeply racialized worldview.
What's fascinating here is that it was the dominant worldview of the political class, and this Anglo-Saxon ideology provides the exact answer to the biggest puzzle of the Mexican-American War, the sudden collapse of the All-Mexico movement in 1847.
Let's go back to that moment in Mexico City. The American flag is flying. The expansionist wing in Washington is clamoring to swallow the whole nation. From a purely imperial standpoint, taking everything is the logical move. You gain complete control of the hemisphere, massive new resources, total dominance.
But the refusal to take all of Mexico makes zero sense through an economic or strategic lens. It only makes sense through Horsman's lens of racial ideology.
How so?
The northern half of Mexico, the 55% they eventually took, was vast, resource-rich, and relatively sparsely populated. But the southern half, the heartland surrounding Mexico City, was home to millions of Mexican citizens, the vast majority of whom were of mixed indigenous and Spanish descent.
The racial Anglo-Saxonism of the American political class looked at those millions of people and recoiled. They deemed them entirely unassimilable.
John C. Calhoun, the incredibly powerful senator from South Carolina and a staunch defender of slavery, stood up on the Senate floor and made the argument explicitly.
He didn't hide it.
No, he argued that the United States was the government of a white race. He stated that incorporating millions of mixed-race Mexicans into the Union would fatally corrupt the biological and political purity of the Republic. He vehemently opposed the All-Mexico movement strictly on racial grounds.
This is the exact moment the template is crystallized. Take the land, not the people. They lusted after the territory of the North, but they absolutely refused to take the densely populated South because their racial ideology simply could not compute bringing millions of non-white people into the American political body.
The collapse of the All-Mexico movement is the strongest, most undeniable piece of evidence for the prosecution in our courtroom today. The physical borders of the United States were drawn not by military limitation, but by the limits of racial tolerance.
I have to pause here because this creates a deeply uncomfortable moral paradox for us to chew on. So, ironically, it was virulent, explicit racism that actually prevented a total imperial takeover of Mexico.
It is a profound historical knot.
The rabid expansionists who wanted to wipe a sovereign nation off the map were stopped in their tracks by politicians who were too racist to want Mexican citizens in their country. The quote-unquote good guys who stopped the total conquest did so for the worst possible reasons. It completely scrambles the traditional morality tale of American history.
History rarely offers clean morality plays. The racial thesis presented by Gómez and Horsman is incredibly compelling. It explains the legal architecture of dispossession and the bizarre geography of the peace treaty. But, as the jury in this deep dive, we cannot hand down a verdict without hearing the other side of the courtroom.
Right. Was race the fundamental engine, or was it a convenient, high-sounding excuse for raw political maneuvering and commercial greed? Let's bring in the counterframe.
Yes, historian Amy S. Greenberg.
Right. In her book, A Wicked War, she asks us to step away from the grand ideological theories of Anglo-Saxonism and look at the messy, contingent, often chaotic reality of how the war actually operated day to day. She argues that the war wasn't a unified ideological crusade.
No, it was heavily contested at home, driven by raw political ambition, the mechanics of party politics, and hard economic imperatives. Greenberg's analysis forces us to look at the immediate political realities of the 1840s.
You cannot discuss this era without discussing the dominant political mechanism of the age, which is the precarious, terrifying balance between free states and slave states in the U.S. Senate.
Every single time the United States looked at a map and thought about acquiring new territory, it sparked a national crisis over whether that territory would permit human bondage.
And the Mexican-American War triggered that crisis immediately through something called the Wilmot Proviso.
Right. David Wilmot was a Northern congressman, a Democrat from Pennsylvania. Right at the beginning of the war in 1846, he attached a legislative rider to an appropriations bill. The proviso basically stated, any territory we acquire from Mexico as a result of this war must be entirely free of slavery.
That single sentence just blew the political landscape wide open.
Suddenly, the war wasn't a unified march of manifest destiny. It was a proxy war over the expansion of slavery. A northern free soiler might vehemently oppose the war, not because they cared about Mexican sovereignty, but because they believed the entire conflict was a conspiracy by the slave power of the South to acquire more territory to carve into slave states.
And conversely, you had Southern fire eaters who supported the war specifically because they desperately needed more slave states to maintain their veto power in the Senate.
But the alliances were incredibly fractured. You also had Northerners who supported the war because they wanted Pacific ports and believed the Wilmot Proviso would successfully keep slavery out of the new lands. And you had Southerners who initially supported the war, but eventually opposed taking all of Mexico because they realized the climate and mountainous geography of southern Mexico wouldn't support plantation-style agriculture anyway.
So, if you are looking at the roll call votes in the Senate, a northern free soiler and a southern fire eater could find themselves voting exactly the same way regarding troop deployments or treaty ratifications, but for entirely different, deeply sectional reasons.
Exactly. The mechanism driving the votes and driving the timing of the war was party mass and the slavery balance, not necessarily a unified belief in Anglo-Saxon destiny.
Greenberg points out that if you follow the political math and follow the money, a lot of the historical map explains itself. The economic imperative was massive. What did the United States practically want out of a war with Mexico? They wanted San Francisco Bay. They wanted the deep-water Pacific ports in California to open up highly lucrative trade routes with Asia.
It's the oldest story in empire building. It's always about trade routes and commerce.
And if you want to see the take the land, not the people template, stripped of all its grand ideological pretensions and reduced to pure, unadulterated commercial greed, you have to look at the Gadsden Purchase of 1853.
Oh, the Gadsden Purchase is such a perfect example.
It's a weird historical footnote. We just fought a massive, bloody war, took 55% of Mexico in 1848, and drew a new border. Why is the United States going back to the Mexican government 5 years later and offering them $10 million to buy a relatively small slice of additional land?
Because of railroads.
Yeah.
American commercial promoters, heavily backed by Southern politicians who wanted to bypass Northern routes, were desperate to build a transcontinental railroad linking the Southern states directly to those newly acquired Pacific ports in California.
But when military surveyors went out to map the land they had taken in 1848, they realized the topography north of the Gila River was far too mountainous for 19th century locomotive technology.
Right. The only viable, flat, year-round route for the train dipped slightly south into territory that still belonged to Mexico.
So we didn't launch another war for ideological destiny. We just pulled out the checkbook and bought a right-of-way.
We bought a 29,000 square mile strip of desert, the Messiah Valley, in present-day southern Arizona and New Mexico, specifically and exclusively for a railroad corridor. We didn't want the land for farming. We didn't want to bring the light of democracy to the valley. We wanted a flat surface to lay iron tracks.
And crucially, there was almost zero Mexican population living in that specific strip of land.
The Gadsden Purchase is the absolute perfection of the template. Acquire the physical ground, acquire zero people, and build the commercial infrastructure.
That is a deeply cynical, purely transactional view of expansion, and it really bolsters Greenberg's point. It's commerce and engineering dictating the borders. And Greenberg also highlights the role of sheer human contingency. the messy, unpredictable individual choices that shaped the era.
History isn't just a march of vast structural forces. It is dictated by individuals making impulsive choices. President James K. Polk didn't wait for a grand mandate of manifest destiny. He deliberately provoked the war by sending American troops into highly disputed territory between the Nueces and Rio Grande rivers, knowing it would spark a conflict.
That was a calculation based on personal ambition and executive power.
And the contingency extends to the end of the war, too. The story of Nicholas Trist, the diplomat sent to negotiate the peace, is just wild.
Trist. Yeah, he was the chief clerk of the State Department, right?
Yes. He was sent to Mexico to negotiate the treaty. But as the military victories mounted, President Polk got greedy. He thought he could demand even more territory, perhaps plunging deeper into Mexico. So Polk officially recalled Trist. He ordered him to stop negotiating and return to Washington.
And Trist just ignores the President of the United States.
He defies a direct presidential order. He realizes that if he leaves, the fragile Mexican government might collapse entirely, and the U.S. would be stuck occupying the whole country indefinitely. So he stays in Mexico without official authorization and negotiates the Treaty of Guadalupe Hidalgo anyway, basically locking in the borders we have today.
Polk was furious, but he had to accept the treaty because the public wanted the war to end. If a different, more obedient diplomat had been in that room, the border might look completely different today.
And we can't talk about rogue actors without talking about the filibusters. Guys like William Walker.
William Walker is the ultimate example of contingency. He was a private American citizen who decided he wanted to be an empire builder. In the 1850s, without any official backing from the U.S. government, he raised private mercenary armies and literally invaded Latin American countries.
It's hard to fathom how a private citizen logistically pulls off an invasion, but he preyed on instability. In 1855, he took advantage of a civil war in Nicaragua. He arrived with a small mercenary force, outmaneuvered the local factions, and actually managed to get himself elected president in Nicaragua for a brief period.
And he was heavily reliant on the logistical networks of Cornelius Vanderbilt's transit companies, which moved people and gold across the Nicaraguan isthmus.
Exactly. And what was his grand ideological goal once he took over a sovereign nation? He issued a decree re-legalizing slavery in Nicaragua, which had been abolished decades earlier.
Which is insane.
It's the ultimate horrific expression of the slave power ambition. But it was also driven by raw personal megalomania and opportunistic corporate alliances with transit tycoons. Walker wasn't acting on a unified ideological blueprint from Washington. He was a rogue actor carving out a personal fiefdom.
So if we look at the defense's case, they are arguing that you don't need a grand, sweeping theory of racial Anglo-Saxonism to explain the 1840s and 50s. You just need to look at the ledger books of the railroad companies, the Senate roll calls regarding slavery, and the massive egos of the men involved. Commerce, politics, and contingency did the heavy lifting.
We have incredibly compelling arguments on both sides of the courtroom. The prosecution has clearly proven that racial ideology explains the refusal to take all Mexico and the systematic dispossession of the Californios through the 1851 Land Act.
Right.
But the defense has clearly proven that commerce and the precarious political math over slavery explain the actual mechanics, the timing of the war, and the specific lines drawn on the map. So how do we, as the jury, reconcile these two truths?
We need a synthesis. We need a verdict that respects all the evidence on the table. It is not a clean, binary victory for either side. It is a deeply layered historical reality. Let me try to frame this synthesis. Think of building an empire, like building a house.
Okay, I like this analogy.
Racial ideology that virulent Anglo-Saxonism Horsman describes is the architect. The architect draws the blueprint and decides the ultimate shape and boundaries of the building. And that shape is take the land, exclude the people, but the architect doesn't actually swing the hammers.
Right, the developers do.
Exactly. Commerce, political ambition, the ferocious debate over slavery. They are the developers and the construction crews. They provide the funding, they decide exactly what day to break ground, and they are the ones driving the bulldozers.
That analogy perfectly captures the dynamic. The developers, Polk, the railroad magnates, the pro-slavery expansionists decided when and where to build. The decision to expand was driven by markets, party arithmetic, and ambition. But they were forced to build according to the architect's blueprint.
The specific form that expansion took.
Right. Annexing half a country, but creating a legal labyrinth to dispossess the residents, inventing a racial binary to subordinate them, and refusing to annex the populated southern half of Mexico. That form was dictated entirely by racial ideology.
So, why does this specific synthesis matter? Why did we spend all this time dissecting the architect and the developers of 1848?
It matters profoundly because this specific form, this architecture of expansion, proved to be incredibly durable. Economics change, the Whigs and the Free Soilers die out and are replaced by new political parties. The issue of slavery is violently resolved by the Civil War.
But the legal architecture of taking land without fully incorporating its people, that blueprint was set in stone in 1848.
It became a permanent tool in the American legal toolbox, available for future generations of leaders to use whenever the empire needed to expand.
And use it they did. Let's pull that blueprint out of the archives and look at how this exact template was reapplied 50 years later as the United States moved from a continental empire to a global overseas empire. Let's look at 1898.
Fast forward to the Spanish-American War. In a matter of months, the United States defeated the fading Spanish Empire and suddenly acquired a massive overseas portfolio: Puerto Rico, Guam, and the Philippines.
And instantly, the exact same constitutional crisis that confronted Congress in 1848 confronts the Supreme Court in 1898. The U.S. wants the territory. They desperately want the naval bases in the Caribbean and the coaling stations in the Pacific to project power and open up trade with China.
But these territories are heavily populated by non-white populations. The ghost of John C. Calhoun is suddenly back in the room. They want the ports, but they are terrified of incorporating millions of Filipinos and Puerto Ricans into the American political body.
The underlying racial ideology hadn't disappeared. It had simply evolved to fit the turn of the century. And the legal solution the Supreme Court came up with was essentially the California Land Act of 1851, but scaled up to a massive constitutional level.
You're talking about the Insular Cases. The Insular Cases are a series of highly controversial Supreme Court decisions handed down between 1901 and 1922. Cases like Downs v. Bidwell. In these decisions, the court was faced with a binary choice. Either the Constitution fully applies to these new territories, granting everyone citizenship and rights, or the U.S. has to let the territories go.
But the court chose a third, entirely invented option. They created a brand new legal category out of thin air: the unincorporated territory.
The unincorporated territory. What does that actually mean for the people living there?
It is a masterclass in legal compartmentalization. The court ruled that these places like Puerto Rico belong to the United States. They are under complete American sovereignty, but they are not fully part of the United States.
The court explicitly ruled that the Constitution does not automatically follow the flag.
So you are ruled by a government, but the foundational document of that government doesn't fully apply to you.
Precisely. The people living in an unincorporated territory are granted certain fundamental human rights, but they are not automatically granted all the constitutional rights of U.S. citizens, like full political representation or the right to vote for president, unless Congress explicitly decides to grant them those rights piece by piece.
It is the 1848 template perfected. Take the land for the naval bases, but keep the people legally at arm's length. In 1848, they promised the California citizenship, but tied them up in court for 20 years to strip their land. In 1898, they take Puerto Rico, but say, well, the Constitution doesn't quite apply to you because you are an alien race. The mechanism modernizes, but the underlying shape is identical.
And this logic doesn't stay confined to formal colonies. It turns outward almost immediately. In 1904, President Theodore Roosevelt issues the Roosevelt Corollary to the Monroe Doctrine.
The classic speak softly and carry a big stick diplomacy.
The Corollary basically claimed that the United States had an international police power over the entire Western Hemisphere. The U.S. claimed the right to intervene militarily in the internal affairs of Latin American nations to maintain order and, crucially, to protect American economic and corporate interests.
And they claim this right without any intention of actually conquering or incorporating those nations into the U.S.
So the template shifts again. We don't even want your land formally anymore. We just want total control over what you do with it and who you trade with.
This is the hinge that connects the 19th century Rancho dispossession to the 20th century geopolitical strategy. The blueprint evolves from land commissions and Supreme Court cases to gunboats and covert operations. The logic of the Roosevelt Corollary flows directly into the era of the Backyard Empire.
We cover the Backyard Empire extensively in our other series, so we won't re-narrate the whole saga here. But the connections are vital. We were talking about the era where corporations like the United Fruit Company El Pulpo, the octopus, dominated the infrastructure and politics of Central America.
We are talking about Standard Oil's reach. And ultimately, the 1954 CIA-backed coup in Guatemala that overthrew the democratically elected president Jacobo Arbenz to protect corporate land holdings.
The exact events are different, but the continuity of the mechanism is undeniable. From Domingo Peralta fighting for his rancho in 1851, to the Insular Cases in 1898, to the CIA operating in Guatemala in 1954, the recurring American maneuver in the hemisphere relies on the same architecture. Control the land, control the resources, control the trade routes, but hold the people living there at a strict legal and political distance from full membership in the American project.
It highlights the brutal efficiency of the law. The tool is refined over time, but the architect's original vision remains intact. Which brings us to the final and perhaps most sensitive part of our deep dive. Because this 19th century legal architecture isn't just a historical curiosity, it is actively playing out right now in the year 2026.
It is essential that we approach this carefully. We are transitioning from analyzing historical events to examining how scholars apply this history to current legal tensions. We are presenting the arguments made by historians like Laura Gómez and Kelly Lytle Hernandez. We're looking at the factual legal architecture of today, not endorsing any political platform.
Let's look at the legal arguments they are making. Lytle Hernandez points out that a modern political system that actively seeks the economic benefits of a territory, namely relying heavily on the labor of immigrants to sustain industries while simultaneously restricting their ability to belong to the nation legally, is a direct structural rhyme with the 1848 template.
To see this in action, we just have to look at the verifiable facts of the 2026 legal landscape, specifically the intense litigation surrounding birthright citizenship.
The facts are these. In 2025, an executive order was issued that sought to fundamentally alter the interpretation of the 14th Amendment. The order aimed to end birthright citizenship, the automatic granting of citizenship to anyone born on U.S. soil, specifically targeting the children of parents who were unlawfully or only temporarily present in the United States.
This executive order immediately triggered a massive constitutional battle. It moved at lightning speed through the lower courts and arrived at the Supreme Court, resulting in the landmark ruling on June 30, 2026, Trump v. Barbara.
Break down the legal reasoning of the court in this ruling because the dates and precedents they use connect perfectly to our historical timeline.
In Trump v. Barbara, the Supreme Court struck down the executive order. Chief Justice John Roberts, writing for the majority, upheld the long-standing interpretation of birthright citizenship. The legal reasoning was anchored firmly in the text of the 14th Amendment, which was adopted in 1868.
1868, right in the aftermath of the Civil War.
Exactly. It was adopted specifically to overturn the disastrous Dred Scott decision and guarantee citizenship to formerly enslaved people, establishing that anyone born in the U.S. is a citizen. Furthermore, Chief Justice Roberts' opinion heavily relied on a crucial precedent from exactly 128 years ago, the 1898 case of United States v. Wong Kim Ark.
1898, the exact same year the U.S. is acquiring its overseas empire and grappling with the Insular Cases.
Yes. The Wong Kim Ark precedent established that the 14th Amendment's guarantee of birthright citizenship applies to nearly all children born on U.S. soil, regardless of their parents' immigration status or nationality.
So the Supreme Court in 2026 is utilizing a constitutional amendment from 1868 and a legal precedent from 1898 to resolve a crisis about borders, belonging, and citizenship today.
It reveals a profound historical irony. Think back to where we started. The Treaty of Guadalupe Hidalgo in 1848 explicitly promised citizenship and legal protection to the Mexican population.
But the U.S. legal system, through the 1851 Land Act, the invention of legal whiteness, and the Greaser Act, found every possible mechanism to break that promise and disenfranchise them.
The 1848 treaty was paper shield. But 20 years later, the United States fought a catastrophic civil war over the expansion of slavery. The very same political issue that Greenberg showed was driving the mechanics of the 1840s expansion. Out of the ashes of that civil war comes the 14th Amendment.
And today, in 2026, it is that 14th Amendment, born from the violence over slavery, that is doing the protective legal work regarding citizenship that the 1848 treaty promised but completely failed to do.
The 14th Amendment is standing in the gap left by Guadalupe Hidalgo. That is an incredible historical loop closing. And it's not just birthright citizenship where these historical tensions remain unresolved. The Insular Cases from 1898 are still active, functioning law today.
They absolutely are. Just this year, in 2026, the U.S. Commission on Civil Rights published a comprehensive final report regarding Puerto Rico. The report methodically details the continuing systemic effects of the Insular Cases and the unincorporated territory doctrine.
It demonstrates that the core constitutional question, how to govern a territory without fully incorporating its people, The question first raised by Calhoun in 1848 and constitutionalized in 1898 is still formally, legally unresolved today.
Nearly 3 million U.S. citizens in Puerto Rico are still living under the shadow of a legal doctrine designed to maintain an imperial distance.
So what does this all mean for you, the listener? Why did we construct this massive historical courtroom and take you on a 200-year journey from Domingo Peralta's lost cattle to a 2026 Supreme Court ruling?
We aren't saying that politicians arguing over border policy in 2026 have the same explicit Anglo-Saxonist motives as John C. Calhoun in 1848. That would be a gross oversimplification of history. What historians like Gómez and Little Hernandez are arguing is that the legal tensions over who belongs, who gets to be a citizen, and how we define the boundaries of the American community are a direct, unbroken continuation of the arguments that started the moment the guns fell silent in Mexico City.
The template of taking the labor and the land while debating the status of the people was drawn then, and we're still arguing over those exact same blueprints today. The past isn't just a prologue you read before the real story begins. It is the very structural foundation of the legal system we currently occupy.
We have examined the evidence, we have heard the prosecution argue for race, and the defense argue for commerce and contingency. It is time to deliver the final verdict.
Let us offer a measured, documentary-style closing argument to weigh the scales honestly.
The 19th century American expansion cannot be understood without the lens of race. The racism thesis presented by Gómez and Horsman is indispensable. It is the only logic that adequately explains the most pivotal and puzzling decisions of the era. It explains why the United States, possessing the absolute military power to swallow all of Mexico, stopped halfway, terrified of incorporating a mixed-race population.
It explains the dark, megalomaniacal dreams of the filibusters like William Walker, who sought to carve out new slave republics based on strict racial hierarchy. And most devastatingly, it explains the targeted, systemic dispossession of the Californios and the deliberate legal manufacture of a subordinated Mexican-American identity through instruments like the 1851 Land Act and the Greaser Act. Race was not a byproduct of expansion, it was the organizing logic of the piece.
But we must respect the counter-evidence. We cannot pretend the Mexican-American War was a single-issue crusade of manifest destiny. We must acknowledge that the timing of the conflict, the political energy required to wage it, and the very specific lines drawn on the map were driven by other immense pragmatic forces.
The bitter domestic political war over the expansion of slavery, the precarious math of the Senate, and the Wilmot Proviso provided the political spark. Pure commercial ambition. The desperate drive for the Pacific ports of San Francisco and the flat railroad corridors of the Gadsden Purchase provided the physical geography. And the unpredictable contingency of human ambition, from a defiant diplomat like Nicholas Trist to a provocative president like Polk, forced the outcome.
The architect drew the racially defined blueprint, but the developers of commerce and party politics actually built the house. The Mexican-American War and its long aftermath represent a profound tragedy of form and timing. Racial ideology gave the American empire its specific shape, a shape that has echoed from the Insular Cases of 1898 right up to the citizenship and territorial debates of 2026.
But it was the relentless hum of commerce, railroads, and political survival that actually drove the machine forward. You need to understand both the architect and the developer to understand the map we live on today.
That is a heavy, complex, and deeply necessary verdict. Thank you to our expert for walking through that intricate history with us. And to you, the listener, thank you for joining this deep dive. We asked you to sit in the jury box for a very long, very complicated historical trial. And we appreciate your time and your curiosity.
It is vital that we continue to stress test these historical narratives because the law never truly forgets its origins.
Absolutely. Now, before we finally adjourn this courtroom, I want to leave you with one final lingering thought. We spent a lot of time talking about the devastating consequences and the exclusionary nature of 19th century racial ideology. But think back to the collapse of the All-Mexico movement in 1847.
Right, when they stopped at Mexico City.
The expansionists had the army in the capital. They had the power to conquer the entire nation. But they stopped, specifically because their virulent racial Anglo-Saxonism made them fear incorporating millions of Mexican citizens into their republic.
The paradox of take the land, not the people.
Right. So here is the question for you to mull over. If the racial ideology of Anglo-Saxonism is what actually prevented the United States from annexing the entirety of Mexico and swallowing an entire neighboring nation whole, does that mean racism actually limited the physical scale of American imperialism? And how does that deeply uncomfortable paradox change how we view the history of borders and expansion? We'll let you chew on that. Thanks for listening.